Now this next topic that we are having at hand today is India's patent regime. Why this was in news? Because United States Trade Representative Special 301 report has been presented. Now, United States Trade Representative Special 301 report has been presented, and this report puts India into countries with countries to watch for United States. Now, what is United States? United States 301 special report said that India was one of the most challenging major economies as far as IP protection and enforcement is concerned. IP means intellectual property. And it has decided to retain India as priority watch list. India as a country with under the priority watch list along with Russia. Okay, now let's see what is USTR Special 301 report. United States can be considered the hub of innovation, right? Now all these countries like India and all, they want uh, the countries like India and other developing countries which are trading partners of USA, United States makes an assessment as to how well is the enforcement and how well is the enforcement of law and protection of intellectual property in its trading partners, because major revenue of USA comes from the protection of intellectual property rights. Like if we consider the very simplest of examples, for example Hollywood films, okay, they have a great viewership in India, but most of them are available online for free, right? And and lot of content that is actually being that can be accessed only by making a payment is freely available in India. So that leads to loss of revenue for the companies in USA, because all these movies and all these OTT platforms, all these companies are from US, right? So counterfeiting and piracy and all these things lead to a loss of revenue to USA. So USA government, okay, USA government prepares a 301 special report every year that makes an assessment of what kind of enforcement and protection of IP laws is present in the trading partners. Okay. Now it assesses, it makes an assessment of challenges with border and criminal enforcement against counterfeit. Okay, border and criminal enforcement against counterfeits means what kind of if a counterfeit is brought into a country across the border, is it being seized or not? Okay, including the online environment. High levels of online and broadcast piracy, as I talked about, the movies, okay, for example, including through illicit streaming devices, okay. Inadequacies in trade secret protection and enforcement in China and Russia elsewhere. This is what 301 report does. It makes an assessment of all these important parameters. Troubling indigenous innovation. Now what happens is these countries like China, they have reverse engineered almost everything that is being designed and produced in USA. Okay, so in the name of indigenous innovation, right? So that, according to United States government, that hurts United States companies. Okay, and that United States government wants to protect the interests of. Other ongoing systematic issues regarding IP protection enforcement as well as fair market access. Now, market access is a clause under TRIPS, basically under WTO. Market access means one country cannot unfairly ban another a company. Basically, when we talk about the concept of most favored nation, what we talk about is कि a country will have to provide, if a country is providing MFN status to a company, that means it will be treating that country with the same privileges as it is treating other countries. That is called the most favored nation status. Okay, now WTO says that, World Trade Organization, okay, says that, and all these treaties say that ki one cannot discriminate unfairly in trade with regarding to the other countries. ठीक है, like India cannot make a arbitrary decision to ban some company from USA and allow some company that is doing the same kind of business from some other country. Okay, there has to be a legitimate reason behind that if one is banning. That is the denial of market access. That is called the denial of market access. So India cannot deny market access to a company from a specific country unless there is a legitimate reason for that. Okay, and if India does that, if India denies market access without providing a legitimate reason, so that country which India is trying to restrict the market access, that country can impose tariffs on Indian goods as well. Okay, understood. So this is what USTR special report is. Now, what are the findings of the report? There are some countries in watch list. However, India has been placed in priority watch list. India has been placed in priority watch list. Apart from this USTR 301 special report, there is another report that is published, that is called Notorious Markets for Counterfeits report. Okay, and 4 Indian markets have been listed. That report was presented in February 2022, and 4 Indian marketplaces have been highlighted in that report. 3 are physical marketplaces and 1 is a digital marketplace. Palika market in New Delhi, Hirapanna market in Mumbai, and Fancy market in Kidderpur, Calcutta. These 3 physical markets have been marked as notorious markets for counterfeits in India. And the one digital market that has been marked as same is IndiaMart.com. So these, in February 2022 itself, this report was published, and these 4 marketplaces were considered to be notorious for selling counterfeit goods and without any fear of law. Okay. Challenges that have been identified with respect to India under this report are patent revocation, lack of presumption of patent validity, and narrow patentability. We'll be talking about this point, narrow patentability, in detail. This is a very important, very interesting topic as well. So we'll be talking about narrow patentability under the Indian Patents Act and poor enforcement of India's Patent Act. It not only says that India's Patent Act is itself weak, it also says that whatever the law is, the enforcement of IP law in India is not very strong. Now let's talk about the patent evolution of patent laws in India. India Designs and Patent Act was enacted in 1911 during the time of British, and then in 1970, on the recommendation of Iyengar Committee was formed to look into the Patents and Design Act 1911 and recommend some changes to make it aligned with the contemporary realities. It was formed in 1959. ठीक है, तो उस कमिटी की रिकमेंडेशन के बेसिस पे पेटेंट्स एक्ट 1970 and along with patent rules 1972 were formed. Now Patents Act 1970 and Patents Act 1972, Patent Rule 1972, both of these provided for some special patents, and it did not provide for registration of drug patents. Okay, that means pharmaceuticals and drugs could not be patented in India. Okay, according to 1970 Patents Act. That means, and this led to actually growth of a huge market for generic medicines in India. Okay, a lot of companies started manufacturing generic medicines in India, and around 1970s, India was one of the country with highest medicinal costs. But this Act 1970, by not allowing the patents to drug and pharmaceutical companies, what it did was it promoted a huge domestic market for generic medicines, because all these patents that were held by other companies in USA A generic version of that drug was available in India, and gradually India became one of such countries where the cost of medicine was lowest in the whole world. And now we know that India is the dispensary of the world. Okay. So this act has played a very huge role. In 1975, India became a part of World Intellectual Property Organization. Now, World Intellectual Property Organization has a lot of treaties. India has signed a lot of them, right? India has signed a lot of treaties with World Intellectual Property Organization, but this organization did not has any teeth to enforce those treaties. Okay, they did not had any teeth to enforce those treaties. Later, India became a part of WTO in 1995 and TRIPS agreement. Okay, so TRIPS agreement is the agreement that talks about intellectual property rights. Okay, and WTO talks about world trade. It is of course it talks about market access and all these related things about the trade. Whereas TRIPS talks about the intellectual property rights. India became the party to WTO in 1995, and that changed the whole intellectual property scene in India. Now, when India became the part of WTO in 1995 and TRIPS, it had the contractual obligation to make its laws in line with the WTO regime. To make its laws aligned with WTO regime, India amended its patent acts in 2003 and 2005, between 2003 and 2005, and a lot of changes like patent for drugs, ठीक है, जो कि 1970 original act did not provide. Now in 2005 an amendment was made and patent of drugs was allowed in India. Okay. One important point is in 2001 Doha Declaration on Public Health was accepted by what? The parties to TRIPS. Now what is Doha Declaration? Doha Declaration on Public Health allows the countries Doha Declaration on Public Health allows the countries to first to it says that any clause of TRIPS or any part of the TRIPS treaty will not prohibit any country from making arrangements for a public health. Okay, that is again the whole law is very critical about drugs and pharmaceuticals. Okay, drugs and pharmaceuticals, because drugs and pharmaceuticals are one sector which take years of research for manufacturing one single drug, right? And for promoting innovation, preserving innovation, it is very important that drugs are granted patent. Now Indian Patent Act 1970 grants patent for 20 years. Okay, grants patent for 20 years. Once this patent expires, the same product cannot be repatented. Very important. The same product cannot be repatented unless there is some very important change that has been done into the formulation of that or into the product itself. That means one patent will expire after 20 years. Okay, now what happened was कि a lot of around 2001 in that period of time AIDS epidemic was prevalent in the world. Okay, AIDS epidemic was prevalent in the world. So Doha Declaration was adopted in 2001, which said that any country can make arrangements for the implementation of public health, ठीक है. Now what are these arrangements that we are talking about? The first one is compulsory licensing. It is very important because this was in news because of COVID. What happened was countries were allowed to manufacture vaccines, the generic versions of the vaccines which were present elsewhere, under the provision of compulsory licensing. Now compulsory licensing is a special kind of license that a country provides to its pharmaceutical manufacturers in special case like medical emergencies, ठीक है, medical emergencies and what medical emergencies and epidemics, ठीक है, or pandemics. So in such critical situations, compulsory licensing can be granted by the country. Compulsory licensing can be granted by the country. Compulsory licensing means country can allow any company to manufacture a product that is otherwise protected by patent. That is otherwise protected by patent. Okay. And each country should have a right to determine. Very important second point of Doha Declaration was each country should have right to determine. It is the most important clause, right to determine what constitutes a medical emergency. Medical emergency. That means the 2001 Doha Declaration talks about the harmony between intellectual property rights and public health. Okay, intellectual property rights and public health, and tries to set a harmony between them. And it allows the countries to grant compulsory licensing in case of a medical emergency. But that medical emergency every country will be free to determine when a medical emergency, when a situation has arisen that it can call a medical emergency. Okay. So that was a very important turning point for developing countries like India. Okay. Now let's talk about India Patent Act 1970 a bit. What is a patent? A patent is exclusive set of rights granted for an innovation which may be a product or a process, both. It can be granted to a product or a process that provides a new way of doing something or offers a new technical solution to a problem. अब यहाँ पे important point जो note करने वाला है कि it offers a new technical solution to a problem or it offers a new way to doing something. Okay, and this is a very important point because lexicography, basically the language of the law, is very important. A patent can be granted only if it fulfills the following. It should be novel. Novel means it should be new. It should not exist prior. It should not exist prior to this. It should have inventive steps. So it must be non-obvious. It must be non-obvious. It should have some steps that look like they are inventive in nature. Okay. So it should be capable of industrial application also. Okay, and it should not attract the provisions of section 3 or 4 of the Patent Act 1970. Now this is the most important clause that is usually in conflict with drug and pharmaceutical companies. Patent Act section 3 of Patent Act 1970, basically section 3D of Patent Act 1970, talks about it restricts the grant of patent to incremental innovations. It does not, it says that if there is a drug, if there is a molecule, for example, okay, this molecule is being provided under certain drug, for example, XYZ. Now, as I talked about in the very beginning, the patents are granted for 20 years. Okay, after 20 years, this patent expired. Now, the domestic companies, the generic will start manufacturing generic versions of this molecule. But what companies did was they made smaller changes into the dosage requirement, okay, dosage requirement, or the molecular structure, very smaller changes into molecular structure, or any such change that makes it a bit different from the original drug XYZ, and they try to again register it as a new patent. Okay. But India's Patent Act section 3D restricts any kind of incremental innovation to be registered. It says that, and there was a very famous case also. There was a very famous case. That case was Novartis versus Union of India. Novartis versus Union of India with regards to a drug called Gleevec. it was a drug used for treatment of breast cancer. Okay, it was a drug used for treatment of breast cancer. Okay, usually the cost of drug was around 1,08,000. ठीक है, it was around 1,08,000. But after the patent of Novartis expired, है ना, तो domestic companies started manufacturing and the cost of the drug was around 8,000 rupees. Then Novartis went to the court and Novartis tried to make some incremental changes into this drug Gleevec and tried to register it again with the patents with Indian government, Director General of Patents. Okay, but that patent was rejected on the basis that it does not bring about a new molecule. It only talks about the existing molecules and you are only changing some basic things, which is an incremental innovation and not a novel product. Not a novel product. And Indian patent law only grants patent to novel products and not to incremental innovations, right? So in that case, Novartis versus Union of India, Supreme Court, basically Madras High Court, and then Supreme Court also upheld, basically it upheld the section 3D. It upheld section 3D of Patents Act 1970, and it cancelled Novartis's request, or it cancelled Novartis's plea, and Gleevec now is selling at cost of rupees 8,000 per drug instead of 1,08,000. So this was a major setback for Novartis and other drug manufacturing companies. That means India does not provide for registration of patents with incremental innovations. That means it should have some new therapeutic advantage to the existing molecule that is already being sold. Understood? I hope you understood that. And section 3D is the most important section of this whole India Patent Act 1970. Okay. Now India, ये बहुत important point एक slide है, क्योंकि India has recently signed a lot of treaties under WIPO. Okay, like WIPO Copyright Treaty, India signed in 2018. WIPO Performance and Phonograms Treaty, India signed in 2018. Locarno Agreement 2019, Nice Agreement 2019, and Vienna Agreement also in 2019. I ask you to go and read what is Locarno, Nice, and Vienna Agreement, and also note it down because it is important. Okay, in your notes, and remember it. What does Locarno Agreement do? What does Nice Agreement do? And what does Vienna Agreement do? Okay. Now another important point that is related to intellectual property rights is the abolishment of IPAB, Intellectual Property Appellate Boards. So Intellectual Property Appellate Boards was constituted in 2003 to hear the complaints, to hear the pleas against the decision of registrar under the Trademark Act 1999 and Geographical GI Tag वाला जो एक्ट है उसके 1999. इन दोनों लॉज के अंडर में अगर कोई कंप्लेन है या कोई प्ली है तो वो हियर करने के लिए IPAB was Intellectual Property Appellate Board was formed in 2003. In 2007, later, 4 years later, Patents Act 1970 and in 2017 the Copyright Act 1957 was also given the jurisdiction to hear the pleas against these decisions under these acts was also given to IPAB. Now the Tribunal Reforms Act 1920 has dissolved 8 tribunals, and these are these ones, and instead the jurisdiction has been transferred to high courts, like the Customs Act, the Patents Act was actually the tribunal that was for hearing the cases of Patent Act was Intellectual Property Appellate Board, is now transferred to High Court. the controller, the geographical indication tag 1999, that act was also with Intellectual Property Appellate Board. It has also been transferred to High Court. And the Trademarks Act 1999, it was also with Intellectual Property Appellate Board. It has also been transferred to High Court. And the Customs Act the Copyright Act 1957, the jurisdiction to hear cases under this act was also with Intellectual Property Appellate Board, which has now been transferred to Commercial Division of the concerned High Court. That now this USTR report has highlighted that this is the government should rethink about it, because IPAB was having the technical expertise to deal with the intellectual property violations, and it was an adjudicative body, whereas High Court is not an adjudicative body. Instead, it will pronounce upon the laws. So it will pronounce judgments upon the laws, and it will not be an adjudicative body. And the tribunal was easy to access. It was a body of IP experts, and that is why USTR report 2000, USTR report 301 that has been recently presented talks about re-invoking the Intellectual Property Appellate Board. It was abolished in 2018, I guess. Oh, sorry, 2021. Okay. So I hope you understood this. If you have any questions regarding this, kindly reach me out in the comment section.